So good afternoon, everyone. So today we have to discuss the Model Tenancy Act 2021, envisioning affordable housing for all. So before we start, let me ask you if I am audible and visible to you. Right? So please tell me if I am. Okay, thank you. So, Model Tenancy Act 2021, yet another milestone in the field of civil law, wherein the relationship between landlord and tenant has been redefined and fine-tuned to an extent that no party, neither the landlord nor the tenant, would be in peril. Okay. So this Model Tenancy Act 2021 defines the rights and liabilities of the landlords and tenants. Because this dispute between the landlord and tenant has been a very turns very serious in most of the cases. The Rent Control Act, and since this is a state, this falls under the state jurisdiction, and tenancy is something which is defined by various state laws, different state laws. The Rent Control Act, earlier the Rent Control Act was so full of so many flaws that no landlord could push any tenant out of his own house. So many rights were given to the tenants. Albeit I did not do any case relating to the Rent Control Act, but so far as I have heard from my father, who is also a practicing advocate, that this law is very, it's like full of flaws, and it's very difficult to get the landlord win the case. Really, are you getting my point? So the Model Tenancy Act of 2021 redefines the relationship between the landlord and the tenant. So envisioning affordable housing for all. The real estate sector is one of the fastest growing sectors in terms of its contribution to India's gross domestic product. Real sector, you would be knowing this, that real estate sector is one of the fastest growing sectors amongst all the sectors. This is the fastest growing sector. If you are living in Noida and if you are living in Delhi NCR, you must be having an idea of how this real estate sector works and at what pace it develops, right? Because this is particularly the region that I have talked about, this Delhi NCR region, where the real estate sector is working and touching new heights because of excessive availability of land in these regions. So this is contributing to India's GDP. By 2025, it is expected that the real estate sector will reach 650 billion US dollars, which accounts for 13% of the GDP. Talking about foreign direct investment, FDI, in the real estate market, the influx in the period 2015 to 2019 saw an 84.4% jump when compared to 2005 to 2014. Right? So this is about a simple data. You should not go into details where it comes from and what is the validity and authenticity of the data. These are the data available on various websites. So by 2025, it is expected that the real estate sector will reach 650 billion US dollars, which accounts for 13% of the GDP. And it's a great figure. Like if 13% of the GDP simply and straightforwardly contributed by the real estate sector, that means it's a big thing. It's a very big thing. So talking about FDI in the real estate market, the influx was from 2015 to 2019. Okay, in the period, it was seen as 84.4% jump when it was compared to 2005 to 2014. So you can see the growth within 10 years. Okay. Growth within 10 years can be seen that it is 84.4% jump. Affordable housing is an important goal of the real estate policy of the central government. However, if you look at this from the prism of the government, the important goal of the central government's real estate policy is to make affordable housing for all very easy. Okay. The government should not be involved in making profits out of the real estate sector. The government's responsibility lies simply in a case where it should be concerned with giving affordable housing to all. Okay, especially after the introduction of the Pradhan Mantri Awas Yojana, under which 112.52 lakhs affordable houses have already been sanctioned. Like this is the data that comes from the government records, that already Pradhan Mantri Awas Yojana has provided 112.52 lakh affordable houses have already sanctioned. However, the need for affordable rental housing is far from being quenched. The 11th five-year plan 2007 to 2012 under the chairmanship of Dr. Manmohan Singh indicated towards an overall shortage of 24.7 million urban housing units, where almost the entire shortage was attributed to the economically weaker sections EWS and lower income group. Okay. Now this 11th five-year plan, which started in 2007 and lasted till 2012, this was under the chairmanship of Dr. Manmohan Singh. I guess you would be having an idea who formulates the five-year plan. It is the Planning Commission, which is known as the Niti Aayog. And who is the ex officio chairperson of the Niti Aayog or Planning Commission? It is the Prime Minister, right? So who was the chairman of Niti Aayog? Dr. Manmohan Singh. So during his chairmanship, there was an overall shortage of 24.7 million urban housing units. Okay. And the shortage was attributed to EWS, the economically weaker sections and lower income groups had to face this shortage. Now you would have understood the problem. The problem lies here. The only solution to this problem for the EWS and LIG is affordable rental housing. See, you can have an idea. This is how the social and economic problems are diagnosed and realized by the government. And based on those problems, the laws are legislated. So basically, the reason for any legislation comes from the society itself. Like we are diagnosing a problem here. Okay, we are diagnosing a problem here that there is an overall shortage of affordable housing units, which are ultimately to be faced by the EWS, the economically weaker section, and also by the lower income groups. Okay. So while realizing this problem, we are to provide a solution. The only solution to this problem for the EWS and LIG is affordable rental housing. For a long time, landowners and tenants have been apprehensive of letting out their property or renting a space respectively. This was majorly due to lack of strict mechanisms for dispute resolution as well as a speedy resolution in case of a dispute. In most of the cases, this was seen that landowners and tenants both have been apprehensive of letting out their property or renting a space respectively. It's not easy because this was majorly due to lack of strict mechanisms. Why would I lend my property on rent if I know that as a lawyer I will not do it? Even after despite being a lawyer, I will not rent my property under the present law, because I know that if the tenant refuses to, vacate my house, there are no strict mechanisms for throwing him out of the house. The dispute resolution is very complex and there is no speedy resolution to the dispute. So most disputes between a landowner and tenant are governed by the Rent Control Act of that state, which are outdated and obsolete. Okay, most disputes between a landowner and tenant are governed by the Rent Control Act of that state, which are outdated and obsolete. In this context, the Ministry of Housing and Urban Poverty Alleviation constituted a task force with Mr. Deepak Parekh, Chairman, Housing Development Finance Corporation Limited, at the helm of affairs. What was the aim of this committee? You read this again very carefully. That Ministry of Housing. See, I told you, I just explained to you in the beginning of the lecture that there is a Rent Control Act. I've told you that this issue of rent, or the, defining the rights and liabilities of the landowners, landlords and tenant, falls under the second list, state list 2 of 7th schedule. And so it falls under the jurisdiction of this every state government. Okay, right. So these state laws are now outdated and obsolete. In this context, the Ministry of Housing and Urban Poverty Alleviation constituted a task force with Mr. Deepak Parekh, Chairman, Housing Development Finance Corporation Limited, at the helm of affairs. So the Ministry of Housing constituted a committee with Mr. Deepak Parekh as its chairman. What was the aim of the committee? The aim of the committee was to suggest means to the ultimate goal of affordable housing for all. The committee in its report pointed out that by alleviating the global housing shortage, the GDP could be increased by 1 to 1.5%. Okay, the aim of the committee was to devise means, was to bring out with solutions which facilitate affordable housing for all. Okay, the committee submitted its report and was of the view that alleviating the global housing shortage, alleviating the global housing shortage, we can increase our GDP by 1 to 1.5%. The committee also suggested that affordable housing should be at the center of public policy. Like most of the public policies which are formulated today, ignore or neglect this issue of affordable housing for all. And this is seriously driving EWS and LIG into slums and into various congested areas. And this is overpopulating and making many of the old areas and neglected areas congested and overpopulated. So this should be at the center of public policy, right? Keeping this in mind, the Union Cabinet approved the Model Tenancy Act 2021. Now you would have understood the whole journey from where this Model Tenancy Act 2021 came from. Like, there was a committee which was constituted by the Ministry of Housing, right? Ministry of Housing and Urban Poverty Alleviation, and the chairman of the committee was Mr. Deepak Parekh. The committee came out with certain means to attain affordable housing for all, and it suggested that affordable housing should be at the center of public policy. Keeping this in mind, the Union Cabinet approved the Model Tenancy Act 2021. The Act aims at balancing the rights and duties of the tenants and landlords by standardizing the process across all the states. This is simply not legislating on the state subject, but this is creating a standard parameters or defining the parameters that based on those parameters, and while attaining that standard, the state should make the law. The state should not make rent related laws out of their own whims and caprices, but rather there is a standard formula made by the central government under the Model Tenancy Act 2021. In this article, the author highlights the changes brought about by the new legislation and analyzes its impact on the existing market, existing real estate market, and the rent control regime. The relationship between a landlord and tenant and the power to legislate on the same rests with the respective state governments. This I have told you in the beginning of the lecture, that the relationship has to be decided and defined by the state governments. The same is covered by item 18 of the state list as given in the 7th schedule. Now, different states in India have different rent control regimes which suits their local requirements. Different states in India have different rent control regimes, like different states have legislated different laws for themselves, different rent control laws for themselves, right? You know what subjects are kept under the state list or under the jurisdiction of the state governments? Only the matters which have a local nature, like agriculture. We cannot have a uniform policy. We cannot have a uniform policy on agriculture because the agriculture in every pocket in India is different. The soil of Bihar is different, while the cultivation in Kerala is very different. So every state has its own agriculture of different nature, right? Similarly, the housing and urban setups in different states are very different, and so this rent control thing is of a local nature and was left to be decided by various state governments, right? Now, different states in India have different rent control regimes which suits their local requirements. Despite laws that suit local conditions, there has been a decline in the share of rental housing in India. This was also concluded by the 2011 census, which stated that the share of rental housing in India declined from 54% in 1961 to 28% of the total in 2011. The number of vacant rentable properties, on the other hand, was constant rise from 6.4 million units 10 years ago to 11.1 million in 2011. This was mainly because landlords were apprehensive to rent out their properties, as recovering their properties post the expiration of the tenancy period was a cumbersome process, right? Why there has been a serious decline? Because in the past recent years, what was keenly observed was that landlords were quite apprehensive while renting out their properties, because they had an apprehension that it would be very difficult for them to get their properties recovered on the expiration of the tenancy period. And if the tenant unfortunately refuses to vacate the house, this is going to be a very cumbersome process to throw him out, right? On the other hand, the tenants were hesitant to rent properties because of the fear of unlawful eviction before the expiration of the tenancy period. Hence, the real estate market across every state was suffering under the previous regimes. So there was an apprehension on the part of tenants also, that they were also hesitant because the landlord can evict them anytime before the expiration of the tenancy period, and this is going to be problematic for them. Second, the ACT under the Model Tenancy Act. What is the ACT? Authority, Court and Tribunal. The new act suggests the establishment of 3 bodies for dispute resolution between the landlord and the tenant. Like this is a welcome provision. This is a welcome provision of the Model Tenancy Act 2021, because if the dispute reaches the normal conventional court, okay, perhaps parties would die, but the dispute would not be resolved. This was seen in most of the cases in civil courts. So the new act suggests the establishment of 3 bodies for dispute resolution between the landlord and the tenant: the rent authority, rent court, and rent tribunal. The existence of a hierarchical structure ensures that if there is any miscarriage of justice by one, the appellate authority rectifies it. Okay. The Act under Section 30 introduces the concept of a rent authority who is to be appointed by the district collector or a district magistrate upon the prior approval of the state government, union territory administration. Such an officer appointed should not be below the rank of a deputy collector. Perhaps he has to be of the IS rank, like he should be an IS officer or a senior PCS officer. Okay, so the Act under Section 30 establishes rent authority, okay, and the person who is to be appointed as the rent authority will be appointed by the district collector or district magistrate upon the prior approval of the state government or the union territory administration, and such person should not be below the rank of a deputy collector. If a person is aggrieved by an order passed by the rent authority, she can prefer an appeal under Section 32 Clause 1 to the Rent Code. Okay. If the rent authority passes an order which aggrieves either of the party, such aggrieved party can make an appeal under Section 32 subsection 1 to the Rent Code. Okay. The Act establishes a rent court under Section 33, which must constitute of an additional collector or additional district magistrate or an officer of equivalent rank, right? Which must constitute of an additional collector or additional district magistrate or an officer of equivalent rank. The process of appointment in this case is same as that of the rent authority explained above. If a person is aggrieved by an order passed by the rent code, she can prefer an appeal under Section 37 Clause 1 to the Rent Tribunal. Right? The language is very simple. After the rent authority, there is a rent code under Section 33. The rent code would consist of an additional collector or an additional district magistrate or an officer of equivalent rank. Okay. The process is same. The process is same because in this case, again, the district magistrate or the collector will appoint the additional collector or additional district magistrate as the rent code. Okay. Right? And if a person is aggrieved by an order passed by the rent code, she can prefer an appeal under Section 37 Clause 1 to the Rent Tribunal. Right? The Rent Tribunal may be established under Section 34 of the Act, and the same will comprise of a district judge or additional district judge for a particular district. Okay? Right? The Rent Tribunal may be established under Section 34 of the Act. Section 34 establishes what? Rent Tribunal. और इसमें कौन होगा रेंट ट्राइब्यूनल में? डिस्ट्रिक्ट जज और एडीजे, एडिशनल डिस्ट्रिक्ट जज फॉर अ पर्टिकुलर डिस्ट्रिक्ट. एक डिस्ट्रिक्ट के लिए डिस्ट्रिक्ट जज या एडीजे होगा. Okay, the use of the term may in the bare text of Section 34 signifies that it is not mandatory for the state governments to establish this tribunal in their districts. The mode of appointment differs to the extent that the rent tribunal is appointed by the state government or union territory administration in consultation with the High Court of its jurisdiction. So it's not mandatory for every district to have a rent tribunal. Okay, Although the state governments can establish such tribunal in every district in consultation with the High Courts of its jurisdiction. In consultation with the High Court of its jurisdiction, right? Have you understood up till here? Any problem? Any problem? ओके सो बात जज्बात तुम नो प्रॉब्लम, मेहुल को भी ये क्लियर हो गया है, किसी और को कोई प्रॉब्लम नहीं है? आर यू श्योर? आर यू श्योर आप लोगों को कोई प्रॉब्लम नहीं है? Ankita is asking a question about how to learn all these sections of laws. See, Ankita, most of the questions which are from the sections of laws, of different laws, are drawn from the passages that are given to you. So you really don't have to worry about learning all those sections. You can find those answers in the passages given to you. Okay? Otherwise, the normal law, the other laws, the laws in the main course like IPC contract, their sections are undoubtedly are supposed to be learned. Okay? Okay? Right? You are not expected to know each and every section of each and every law. Not even the senior most lawyer and the best lawyers of the country can do that. That is not possible. So addressing the lacuna in the previous regimes, let us now have a comparative analysis of what were the lacunas in the previous regimes. Okay. Issues faced under the previous regimes and solutions provided under the new act. Under the previous regime, there was a delay in resolution of disputes between the landlord and tenant because of lack of any fixed resolution timeline. Okay, there was no timeline within which or based upon which the resolution was to be conducted. Okay, the dispute used to linger in courts for many years to come. Okay. Ankita, now let us first understand this. Let me discuss this topic first. Okay. Solution is that under section 35 clause 2 of the act, a time limit of 60 days has been set for the rent court and rent tribunal to dispose of applications filed before them. So there has to be a time bound dispute resolution. Okay. Earlier there was no time bound. The dispute resolution was not time bound. But under section 35(2) of the Model Tenancy Act 2021, a limit of 60 days has been set for the rent court and rent tribunal to dispose of applications filed before them. Right? The previous regime was only applicable to a certain rent bracket. For example, according to section 3(1)(c) of the Delhi Rent Control Act 1995 is only applicable to those households with a rent more than 3,500 rupees. Okay. there was a certain rent bracket which was provided. Like the Delhi Rent Control Act was applicable only to those households with a rent of more than 3,500, more than rupees 3,500. So this brought the houses below 3,500 under the cloud of ambiguity. Now the present act is applicable to everyone who has entered into a tenancy agreement under section 4 of the act and informed the rent authority of the same. Thus the process under the present act is more democratic and inclusive in nature. There are no rent brackets provided under the new regime. Okay. If anybody is entering into a tenancy agreement under section 4 of the act, then he simply has to inform the rent authority of the same, and it may be of any, it may be of any amount. The rent may be of any amount, right? Third, the registration process under previous regimes was paper intensive and acted as a deterrent for landlords and tenants against registering their tenancy. Okay. Paper intensive, 11 महीने के agreement, usually 11 months agreement was to be entered by the landlord and tenant, because अगर 12 months का करवाते तो फिर उसका registration जो है वो compulsory हो जाता. 12 months, any rent agreement of 12 months or more was mandatorily to be registered. So people used to enter into 11 months agreement and then they used to renew it every 11th month. So the registration process under previous regimes was paper intensive and acted as a deterrent for landlords and tenants against registering their tenancy. It was so much of complexities and red tapeism was so much involved in the previous regime that it prompted the people and the landlords and the tenants to not get their tenancy registered, but rather enter into an 11th month agreement. Okay, but what is the case now? The registration process under the new act has been moved to a digital platform. Section 4(3) of the act mandates the rent authority to set up an online portal wherein the landlord and tenant can submit their documents for registration. There's simply a digital platform given. Okay. Rent authority who shall be informed as soon as an agreement is entered into between the two people. The rent authority will set up an online portal, and on that online portal the landlord and the tenant will submit their documents for registration. Okay. Then fourth, what happened in the previous regime? Owing to a lack of any fixed rate of security deposit, there was no check on the landlord as to the quantum of deposit asked for from the tenant. Hence, the landlords had a free hand to decide the amount of the security deposit. Okay. Like there's a security deposit which every tenant has to make to the landlord before entering into a tenancy agreement and taking the possession of the house, right? So landlords used to ask a huge amount for security deposits. They had a free hand to decide the amount as per their wishes. You know what happened? You can understand there are these kinds of things in Bangalore, in Mumbai, in Hyderabad. So in cities like Delhi, Mumbai, Bangalore, Hyderabad, landlords, they are asking huge amounts of security deposits, which are in most of the cases quite unaffordable for majority of the people. But now, what is the situation now? Section 11 of the present act puts a cap on the security deposit that the landlord can ask for, which is 2 months rent in case of a residential property and 6 months rent in case of a non-residential property. Okay. Like slabs have been created. Some brackets have been created here. What kind of brackets? That if it is a residential property, the security amount can be up to 2 months of rent. Okay, like for example, 5,000 is the rent of the residential property. The landlord can ask 10,000 as the security deposit, like 2 months rent in case of a residential property, and 6 months rent. And if it is a non-residential property, then 6 month rent can be taken as a security deposit. 6 months rent means like 5 6 are 30,000. Okay, in case of a residential property. Now this 5,000 and 30,000 and 10,000 is just an example. I gave this figure to illustrate a point. Don't take as the legal figures. Okay. Then the previous regimes had no trace of any force majeure clause, especially in the context of the COVID-19 pandemic, to extend the tenancy during that period. Like during the COVID-19 pandemic, there was no such clause in the tenancy agreement that if such kind of pandemic or unforeseen circumstances prevail, what will then the tenant do? If his or her tenancy is expiring on a date during the lockdown, so it is not possible for the tenant to vacate the house and go and search around another place for him, right? So there was no trace of any force majeure clause. Now see what is the situation. Section 5(3) of the Act provides for a force majeure clause wherein under specified circumstances the tenancy will extend till a period of 1 month from the date of cessation of such disastrous event. If there is any such disastrous event, the tenancy can extend till a period of 1 month from the date of cessation. Like from the date when the tenancy is expiring, from that date up to a period of next 1 month, the tenancy can be extended in case of such disastrous event. Have you understood these points? Next. Under the previous regime, there was an absence of any arm twisting mechanisms for the eviction of tenant in case of non-payment of rent. Okay, like this can be seen that arm twisting mechanisms are like if the tenant is not paying the rent, the landlord can throw his luggage and belongings and furniture out of the house and can do anything with the tenant, right? Can resort to violence in such cases. Under section 23, if the tenant has not paid the rent and not evicted the premises, then a penalty of twice the monthly rent for the first 2 months. Thereafter, 4 times the monthly rent may be imposed. Okay, so the landlord should not resort to violence, but rather he may have a recourse to the process of law, right? Wherein a penalty of twice the monthly rent for the first 2 months, like if the rent is 5,000, for example, if the rent is 5,000 and he is not paying the rent, then it will become 10,000 for a month for the first 2 months. Okay. Thereafter, agar uske baad bhi pay nahi kiya, still he is not paying, then it will become 4 times the monthly rent may be imposed. So 4 times the monthly rent means, like for example, it is 5,000. So 5 was a 20,000 per month will be imposed as a penalty then. Okay. So you can understand, after making this comparative analysis of both the rent control regimes, the older one as well as this new one, you can understand that there were so many flaws that the older rent control regime was suffering from. There were so many shortcomings and handicaps it was suffering from, and all those handicaps and shortcomings have been overcome by this new Model Tenancy Act of 2021. Have you understood these points, or you encounter any doubt? Please, if you are facing any problem, you're most welcome to ask. Please. Any problem? Jazbat has understood. I guess everyone else has also understood. Zinnia is asking, where is it providing a remedy for those who refuse to vacate the premises? First of all, Zinnia, this comparative analysis does not cover all the provisions of Model Tenancy Act 2021. It simply take out the key points which have been incorporated into this article. Secondly, if the tenant is not vacating the premises or is not getting evicted from the premises, simple, the landlord has to make a resort to the rent authority in the district. Then the rent authority will decide this. Why these authority, court and tribunal, the ACT standard which has been incorporated in the Model Tenancy Act 2021, what will it do? It will simply make sure that the tenant vacates the house on the expiration of the tenancy agreement. Okay, there is a rent authority, then there is a rent court, then there is a rent tribunal. There are three hierarchical authorities which have been created here. So what are they for? Okay. Understood, Zinnia? Accordingly, the penalties will be imposed by these authorities, the rent authority, rent court and rent tribunal. Okay. Understood? Okay, Zinnia. Now, next is conclusion and analysis. The Act aims at streamlining the powers and duties of the landlord and the tenant, which were till date managed by archaic state rent control laws. Now, all the powers and duties of the landlord and the tenants have been fine-tuned by being redefined, and all those archaic set of norms which used to control the rent regimes on the past in different states have been set aside. Archaic means outdated, old. So all these powers and duties have now been properly streamlined. The novel provision in the present act, namely force majeure, prohibition of subletting, will not only act as a confidence building measure for both the landlords and tenants, but will also boost the real estate sector with an influx of new rent properties. Okay, if I have a strong belief that I can, without any apprehension, I can let my property on rent, okay, then this is the law. This law would help me help me believe it strongly that in case the tenant indulges in any corrupt act, I can have a recourse to the rent authority, rent court, or rent tribunal and get my grievance redressed. So the provisions like force majeure provision or prohibition of subletting. What is subletting? किराए पे उठाया आपने, you gave your house on rent to a tenant, and the tenant further a part of it was let by the tenant to some other person. Like किराएदार ने खुद किराए पे उठा दिया उसको, तो सबलेटिंग के प्रोहिबिट कर दिया गया है. फोर्स मेजोरे prohibition of subletting will not only act as a confidence building measure for both the landlords and tenants, but will also boost the real estate sector with an influx of new rent properties. The act also permits under section 35 clause 1 the rent court and the rent tribunal to deviate from the procedure under the Code of Civil Procedure 1908, okay, and follow their own procedure. Like, this is the best part. You know that the procedures under Civil Procedure Code 1908 are very complex and very much time consuming. They are so cumbersome that it becomes a headache for the lawyer himself to follow all the procedures under the CPC 1908. What is the best part of this law is that section 35 clause 1 allows the rent court and rent tribunal to deviate from the procedures of the CPC, and they can follow their own procedures. This will help in expediting the process. This will speed up the process, as the time taken for formal procedures can be reduced substantially, and will also provide flexibility to the rent court and rent tribunal. आप लोगों की बात समझ में आ गई? इससे क्या होगा, जो टाइम कंज्यूम होता है यूजुअली फॉर्मल प्रोसीजर्स में, कोर्ट में फॉर्मल प्रोसीजर्स हम फॉलो करते हैं, तो टाइम कहां लगता है? फॉर्मल प्रोसीजर्स में लगता है ना, राइट? स्पेशली इन द सिविल लॉज. क्रिमिनल तो फिर भी बहुत जल्दी डिसाइड हो जाते हैं, बट सिविल they take a lot of time because of the red tapeism hidden in the bare text of the CPCs, laws like CPC. But this deviation, this liberty to deviate from the procedure under the CPC and follow their own procedure, this will help in expediting the process or speed up the process, as the time taken for formal procedures can be reduced substantially and will also provide flexibility to the rent court and rent tribunal. The big issue that still remains is the implementation of the provisions of this act. Like again, like every law, you can make significantly beautiful laws, but you know what is the major problem in our country? It is the implementation of the laws. We have so many good laws, but we do not have proper implementation. So the writer is trying to say is that the big issue still remains is the implementation of the provisions of this act. Land being a state subject is under the legislative control of the states, and states have the discretion to adopt this act in its entirety, partially adopt it, or not adopt it at all. You know, the central government, the parliament has legislated this law, but the state governments have the option of either accepting the whole law as a whole, or partly adopt it, or do not adopt it at all. Okay, so for instance, like states like Maharashtra are already considering to only partially adopt the act because of the land is of local nature and there are certain local things involved in various state laws. So Maharashtra seems reluctant to adopt the whole act in its entirety. It's going to adopt the act but partially. The state discretion will bring the entire discussion back to square one. The state discretion, this will bring the entire discussion back to square one, like जहां थे हम वहीं आ जाएंगे. अगर स्टेट्स ने इसको अडॉप्ट नहीं किया तो हम जहां थे वहीं आ जाएंगे. नॉन स्टैंडर्डाइज्ड रेंट कंट्रोल अक्रॉस डिफरेंट स्टेट्स. Like we are already having this problem of non-standardized rent control across different states, and that's what we are going to continue with if the states exercise their discretion and not adopt this act at all. So since the Model Tenancy Act of 2021 has created a standard parameters for the rent control, the states should go for it. And if the states have been given this discretion, this is going to be very dangerous, because this will bring us the whole situation back to square one. Certain aspects of the act still require fine detailing. For instance, the citizenry in Maharashtra is under the fear that once the act is implemented, the landlords will be able to revise the rents, which was 15% a year under the previous regime. Like they are apprehending that हमें previous regimes में हम हर साल 15% rent बढ़ा देते हैं. Like we increase 15% rent every year. Are we going to have this power to under the new act also or not? The central government should initiate a discourse with the state governments and the people, apprising them about the intricacies and the benefits of implementing the act. To ensure nationwide implementation, starting step can be offering incentives to the state governments in return of implementation of the act. This has been previously done when the center had allowed the states to borrow 2% of gross state domestic product, half of it being contingent on implementation of 4 specified reforms. If the center is successful in persuading the states to implement the act, then this legislation will prove a boon for both the landlord and tenant, as registration of tenancy agreements will become a norm, making the entire process much more transparent and fairer to both parties. Now, if you have any problem or question, you're most welcome to ask. No questions? Mehul has understood. I guess everyone else has understood, because I'm not seeing any question. So I am now signing off. Okay, Zinia, thank you. Thank you all, and I am now signing off. Hope to see you tomorrow with a new topic. Okay, till then, bye bye.